All right, we're back for a quick one here. This is the Seventh Amendment. This is the American Man podcast. I'm here with my son Elijah. So let's just read it real quick. This one's not going to take too long.
In suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law.
All right, so there's just a few things that we can break down from here. So first of all, we've been talking a lot about criminal laws and your right to face your accuser and things like that. What do you feel like this one? What sense do you get that this type of thing is about?
I don't understand a lot of the big words, so I'm not exactly sure what it means.
Yep. So it says the value in controversy shall exceed $20. So does that sound like a criminal thing or maybe a dispute between two people?
Well, what is controversy mean?
Just controversy is just a dispute, disagreement.
Oh, okay.
So what we have here, it's a difference between criminal law and what we basically nowadays call civil law. Civil means between two parties. So that if you remember the Civil War, right, was two sides of the same country. And so we have suits at common law. Common law in the I'll say the old days. Back then, common law was law that was basically handed down from prior court decisions. Not necessarily that there was a statute, a specific law on the books that said, that if you aren't looking where you're going and you accidentally knock over a valuable, plate and it breaks, then the person is allowed to sue you. It wasn't written into the state law books, but we call that sort of thing negligence. And it was formed. Those types of laws were formed in what we call common law, just from decisions of courts, from way back in England and handed down through the common law tradition in the United States. So when we have a law that basically says, "Oh, you were negligent. You should have looked, before you drove out into that road," or you failed to do something that you should have done, taken a precaution. That's what we call common law. And so here we're talking not about laws that are, it's illegal to attack a person or to murder a person or to steal, but there are disputes between people that are settled by our courts. And that's what we're talking about here with common law. Now, $20, that doesn't seem like a lot nowadays, but back then it did.
What's 30 times 20?
Right. Nowadays we actually have what's called a small claims court for a lawsuit that's under $10,000. That goes to small claims court, and it has a different procedure, and you don't have the right to a jury trial in a small claims court. So that's basically stems from this amendment. But what it's saying here is if there's some big thing that has happened, if someone has caused you injury, someone hit you with a car, someone did something that destroyed your house or really damaged you, or they something like that, you have the right to a jury to make that decision. Do you remember what we talked about? What is a jury?
Like people who write things down, and they aren't like witnesses, are they? They just
No, they
keep track of
listen to the
things.
witnesses and then they make a determination on what they think happened.
Yeah.
And so they are what we call the fact finders. So there's certain laws that someone may have violated one of those laws, and the jury, they are the ones who make the decision whether they think that you did something or failed to do something that broke that common law and injured someone else. So again, we're talking about the importance of being judged by people in your community, a jury, right? And not a judge who might be influenced or by different things, political pressures and things like that. Now, these days, there's actually a lot of things that you may not have the right to a jury trial for. There are what we call suits in equity, where the judge is the one that decides whether something's fair or not, things like that. So you don't always have the right to a jury trial in every civil matter. But there are, for the most part, you have the right to demand a jury trial. So when it says no fact tried by a jury shall be otherwise re-examined in any court of the United States, what does that sound like to you?
So no fact or thing tried by a jury. Tried? What is that exactly?
It means like there was a trial and a jury made a decision.
Mm-hmm. Okay. Shall be otherwise re-examined. You're not allowed to look into this more in a different court or judge isn't allowed to look and hey, maybe there is still something that I might find. I still want to try and prove this or something.
So that's close. And what this comes down to is if the jury says, we think the light was red, the judge can't turn around, or a court of appeals, like if you lose a case, you can appeal your case to a higher court. The judge or the higher court cannot turn around and say, no, I think the light was green. So if the jury makes a factual determination, we believe the light was red, and you ran a red light and you caused an injury, the judge can't say, no, I think that the light was green. Now, there are some circumstances when a judge can look at the evidence and say, based on the evidence, there is no possible way that any reasonable juror could conclude that this particular thing happened. So there is a safeguard. So let's just say there's a camera that shows the intersection where the red light was, and there are 20 eyewitnesses, and you have a computer built into the red light system that has timestamps, and every witness says the light was green, and the timestamp on the camera says the light was green, and the recordings say the light was green, and one of the people standing by the light had an iPhone and they were filming it, and the light was green, and all this stuff gets introduced. But for whatever reason, the jury comes out and says, we think it was red. A judge can overturn a jury if no reasonable person could conclude, based on the facts, that a certain thing happened. So we do have this amendment. It protects our basic rights. Judges do have some authority to override findings when there's almost, there's no possible way that you could come to that conclusion. But when the judge is looking at it, or if you appeal it to the Court of Appeals or the Supreme Court, they give what's called deference to the fact finder. They give deference to, or they defer to, which is basically, I'm going to agree with whatever the jury said was the factual case. Now, that doesn't mean a court can't throw it out. Maybe the judge instructed the jury on the wrong law, or there was a legal procedure that was done improperly, things like that. We try to separate factual things from legal things. And we always try to have the juries make decisions on the factual things. And then the judges and the courts, they instruct them on the legal things. So what that usually comes down to looking like is the judge will tell the jury, okay, you've heard the case, you've heard the facts. The defendant is guilty if they did X, Y, and Z. If they were controlling a vehicle, they ran a red light, and they caused damage. Those are the legal requirements to find them guilty. So the judge is going to decide those things. And if they get those wrong, those things can be appealed and reviewed. But it's the jury that then decides, was the person actually driving the car? Or was it someone else driving the car? Did they run a red light? Did they actually cause damage? Those are factual things. That's what we talk about. No fact tried by a jury shall be otherwise re-examined. So that was pretty straightforward. Although there's a ton of nuances to it. It's not as impactful as we might think as some of these others. But again, we're just trying to make sure that it's up to the people and the people that surround us in our communities. Those are the ones who are going to be deciding, these court cases, whether it's criminal or civil, and not just, not a king or not some, governor appointed by the king, or not, again, we're talking about Revolutionary War just happened, and we're talking about how to protect our freedoms from, abuse. So that's why we have the Seventh Amendment.